In New York State, a bank employee notarizes a mortgage agreement for a customer. The employee is also the loan officer responsible for approving the mortgage and is named as a beneficiary in the bank's employee incentive program, which gives bonuses for originating loans. Under the New York Notary Public Law, is the notarization valid? Well, if we look at the New York Notary Public Law, particularly the Notary Public License Law booklet, it states under the header of Notary Public Disqualifications, though a person may be eligible to hold the office of notary, the person may be disqualified to act in certain cases by reasons of having an interest in the case. To state the rule broadly, if the notary is a party to or directly and pecuniarily interested in the transaction, pecuniarily means having a financial interest in the transaction, the person is not capable of acting in that case. So with this in mind, let's have a look at our four choices to determine the solution. Choice A states, yes, because the bank employee followed all formal notarization procedures. Well, whether or not the bank employee followed formal notarization procedures is discounted by the fact that the bank employee definitely has a financial interest in notarizing here. And as we read from the law, in such a case, the notary public cannot notarize. Therefore, this choice is not the correct solution. We can strike it out. Choice B states, no, because a notary public is not allowed to notarize any banking documents. Well, this is incorrect. A notary public can notarize banking documents, but not in cases where there's a financial interest. However, but for the notary public's financial interest in this instance, the notary public would have been able to notarize. So this blanket statement forbidding the notary public from notarizing banking statements is incorrect, and we can strike it out. Choice C states, no, because the employee is directly financially interested in the transaction. This aligns with what we read from the law before, but just before we mark it as the correct solution, let's have a look at choice D to be certain. Choice D states, yes, as long as the customer did not object to the employee's participation. Now, the law does not make allowances for whether or not the employee objects. If the notary public has a financial interest, then that notary public cannot notarize in that instance. Therefore, choice D is not the correct solution, which indeed leaves choice C, no, because the employee is directly financially interested in the transaction, as the correct solution.